Hey Realtors, it's Austin Smallwood with the SCR Legal Hotline to go over an upcoming change to SCR Form 313, the Notice of Termination. Like all the other upcoming forms changes, these will take effect on September 12th and will be available wherever you currently get your forms. We will be having a webinar on August 31st at noon to go over all these forms in more detail, but certainly encourage you to watch this video along with all the other videos that we are putting on our YouTube channel regarding these upcoming forms changes. So this change is being made in order to address some of the questions we get on the hotline about when it is appropriate to use a notice of termination and when it is appropriate to use a release. So you'll notice at the very top, this form cannot be used to disperse earnest money. That is only for the release. Notice of termination is a unilateral document. Release is a two-party document. As required by license law, you cannot disperse earnest money without both parties agreeing or a court order. So notice of termination form cannot disperse earnest money and should never be used for that purpose. So what we've added is in this paragraph 4 is now the party who is sending the notice of termination, and notice of termination could be sent by the buyer or the seller depending on the circumstances. They will check the reason for terminating. So if you have a client who says, I no longer want to be in this transaction, I want to terminate, you can refer to this form to them and say, hey, all right, now there's options that are available to you. Which of these boxes in A applies to your situation? If none, then we're going to have to go to option B, which we will get to in a second. So what are the valid reasons for terminating a contract under SCR Form 310? These are the options that are currently available in your contract that are unilateral rights by one of the parties. The first one is the buyer terminating under due diligence, and the termination fees can be delivered. Second one is one of the parties is terminating because financing has been denied. The third is the buyer's terminating because of the appraisal contingency. The fourth is that the buyer's terminating because of the CL100 contingency. The next one is that either party is terminating because of the provisions of the buyer sale contingency in SCR Form 504. The next one is that the seller is terminating because the buyer did not timely deliver the earnest money. And the last one is because of maybe some other contractual obligation, some other contingency that's not listed out there. You would fill that out in the blank. This is not just a blank, I would like to terminate. This needs to actually be tied to some contractual contingency, hopefully drafted by an attorney, which states that one of the parties has a unilateral right to terminate. That is the entire list of reasons for which a party can unilaterally terminate the contract. If one of those apply, check the appropriate box, have the sender sign it. Again, unilateral communication, there is no need for the recipient to sign that form. B is where we get into, so when you have a party who wants to terminate and none of the options in A apply to them. Well, the only other way they can terminate is B, which is not in fact actually a termination. That is an invalid termination. That is essentially a notice for litigation. And so why B says, sender is sending this notice of termination without a contractual basis to do so, and is fully aware that terminating under these conditions may result in legal claims for damages by all affected parties. This is not a valid termination. So if you are representing a party who is sending this and checking B, you need to make sure you have notified them in writing that they should also be talking to their attorney, because there is likely going to be some litigation or at least discussions with attorneys that follow with this. So those are the only changes that are happening to Form 313. Again, nothing that practically changes with how the form is used, but hopefully that this paragraph 4 will offer a little bit more explanation on when it is and is not appropriate, and will be helpful when explaining that to your client. With this form and any of the other forms, certainly if you have any questions, give us a call on the legal hotline or email me at austin@screaltors.org, and I'll be happy to help you the best I can. Thank you.